Hello friends, in the series on the income tax cases, today we will discuss the case of Commissioner of Income Tax versus GOYANKA Lime and Chemical Limited. This case has been reported in 453 ITR at page number 242. The matter has been decided by Supreme Court. In this case, the approval given by the Joint Commissioner under Section 151 was under consideration. As all we know that when the cases are reopened under Section 148, whether it is beyond going 4 years, whether it is for the 3 years or as the case may be, the assessee has to bear the pain of assessment in the form of arranging various documents, various confirmations, various bank statements, various demat accounts and all the documents which are necessary for completing the assessment. So it is not an easy task. Suppose you reopen a case of an assessee which is for the 6 years back. So 6 years back means a very long period. So there is enough safeguard provided in the statute itself in the form of Section 151 approval that before taking such a harsh action on the assessee, the approval of a higher authority is necessary and that approval should be in the real sense. There is an amendment in 2008 in Section 151 and there is also a circular of the department which says that the Joint Commissioner does not have to issue any notice to the assessee for giving the approval. He has to just see the reasons which has been recorded by the assessing officer and have to give his approval. But a number of the cases have decided in favor of the assessee where the approval has been given in a mechanical manner, like in this present case. When the approval was given in the case of the assessee, it was just marked on the approval letter, yes, I am satisfied. This was the general template which is being used by the department. It shows that the approval which is necessary under Section 151 has become a mockery in real sense. It does not have any meaning. As all we know that at the fag end, when the limitation period is going to expire to issue the notices, the assessing officer records the reasons and went to the higher authorities. They give the approvals in 100 or 50 cases in a day. So it all shows that the higher authorities are just being used by the department as a rubber stamp. They do not apply their mind whether it is a fit case for issuing the notice under Section 148. In some cases, the reasons are so vague that it is not practical possible that the notice under Section 148 should be issued. So, in this case, the CIT appeal and the ITAT also gave relief to the assessee on this point that the approval is mechanical. The department moved to the High Court and High Court also, by relying on the famous judgment of Arjun Singh versus Assistant Deputy Commissioner of Income Tax, upheld the order of the ITAT. The department as usual moved to the Supreme Court and the Supreme Court said that the approval in this case is a classic example that the Joint Commissioner has just signed the dotted lines and there is no application of mind by the Joint Commissioner in giving the approval. When the approval will be given in this manner, then it is an indication that they have not applied their mind, they have just signed the paper of approval on the reasons recorded by the assessing officer. So the quality of the assessment and the quality of the approvals will deteriorate and the confidence of the assessee will lose in the tax administration system. Friends, this case is very important because whenever an assessment is completed under Section 147, it should be the approach of the assessee that the assessee should raise the RTI and should get the copy of the approvals of the Joint Commissioners or the Commissioner as the case may be, and also some papers like when the assessing officer went to the Commissioner for getting the approval and what is the time taken by the commissioner for giving these approvals, because in this case the court also said that the reasons recorded by the assessing officer and the approval given by the joint commissioner, there was time gap of less than 24 hours. So it also means that the approval was mechanical. At the end of this video, once again I am repeating the name of the case. The name of the case is Commissioner of Income Tax versus S. GOYANKA Lime and Chemical Limited, and this case has been reported in 453 ITR at page number 242. Thank you, friends.